I'm Gretchen Helfrich. I'm an attorney here at Loevy and Loevy. One of the areas of law that we've focused on at our firm is prisoners' rights. We represent a number of prisoners who've been subjected to excessive force, been deprived of medical care, or otherwise had their constitutional rights violated while incarcerated. Today, we're going to hear from Sarah Grady. Sarah is also an attorney here at Loevy and Loevy, and Sarah specializes in prisoners' rights litigation. She's just started a 7th Circuit prisoners' rights Listserv. Hello, Sarah.
Hi, Gretchen.
So tell me what the Listserv is.
The Listserv is an email list for practitioners who practice in the 7th Circuit and either currently have cases involving prisoners or are interested in prisoners' rights litigation.
Now, have there been other listservs like this? I mean, is this just a regional one or is this the first one? What do you know about that?
There are a number of similar email lists. There is a national prisoners' rights listserv that really the members of that listserv focus, I would say, predominantly or exclusively on prisoners' rights in their practice. Our email list is designed to be in a sense more inclusive of people who perhaps are appointed to represent prisoners in one case and have more basic questions about how to do this work and how to litigate against these types of defendants. It can be a very different area than other types of federal litigation, and so it is very different and unique in that sense, but certainly my involvement with the National Prisoners' Rights Listserv helped spur the idea for this regional email list.
And so far, how many people have been appearing on the listserv? How many people are looking for information about prisoners' rights litigation?
Currently, our membership is somewhere between 70 to 100 members, and we anticipate that it will grow exponentially as appointed attorneys become made aware of the email list and this resource that they can use to ask questions ranging from as simple as how do we serve prison officials who work in a prison all day that we can't access to more complex questions about strategies for litigating on behalf of incarcerated people.
So that's what I was going to ask you. What kinds of questions or what kind of issues are people bringing to the listserv to get resolved?
It is a wide variety of questions and suggestions made by and for practitioners. Some of them are those simple questions about service, or experts is another one that has come up repeatedly. We get emails about whether or not there are people who are interested in taking a case. Those come through the listserv as well. The listserv is quite new, so the number of questions is still relatively small, and I think people are really just starting to get a handle on what they'd like to ask to a large audience. But we are encouraging people to ask questions that really run the gamut from the very most basic questions about service or about who even is a proper defendant given state immunity or questions like that, to strategic questions about litigation and briefing and other issues involving what can and should be brought in the court. And it's also a great resource for people who want to learn about developing issues in prisoners' rights litigation. We have a very involved group of people who both send around cases and discuss what those cases do and don't mean for prisoners' rights litigation.
Well, I want to ask you about that, about what the issues are and where the law is moving in prisoners' rights litigation. But before we get to that, tell me a little bit about where you see this listserv going. I mean, what is it that you hope to accomplish by setting this up?
What we hope to do with this listserv is allow the prisoners' rights bar, including, again, people who have been appointed by judges to represent these prisoners, to effectively and efficiently provide that representation. And there is, I think, a very steep learning curve that every lawyer who is assigned or chooses to represent a prisoner must go through about what that means.
I can agree with that. Having worked with you on a few cases, I can agree with that.
Exactly. There is a whole very unique set of rules that apply to prisoners. And that takes a long time to navigate, learn, get up to speed on, become an expert on, such that you can very efficiently and effectively advocate for your client. And what we hope to do is cut down on that time and cut down on the confusion about how to do this type of work. Oftentimes, the court ends up relying on the defendants, who are the repeat players in these cases, because the plaintiff's lawyers, it's the first time that they've represented this kind of a case. And so we're hoping our email list serves as a resource for people to ask all sorts of questions that they need to know in order to effectively and efficiently represent their client, and also to help advance the interests of prisoners as a collective whole.
Do you think that people who do bring litigation, either while they're incarcerated or after they've been incarcerated, do you think that they are suffering, or their cases are going worse because of a lack of expertise among the lawyers who represent them?
That's an interesting question. I think that we have made great strides, especially in the Seventh Circuit, with the recognition that attorneys are necessary to represent prisoners. For a long time, many of these lawsuits were being litigated by prisoners pro se, and you can imagine all of the limitations that would entail. People who can't take depositions by nature of security restrictions, people who cannot see many of the documents that are very critical to discovery because of their status as a prisoner. So I think we've made great strides. Now, that being said, I think, like any case, what happens when a person is appointed in a case in a field, a case involving a field of which they have no knowledge, there's a lot of time spent getting to know the very basics. And that's important. And if you don't have a resource like the Listserv, what we hope the Listserv to be, it's required. There's really no other way to go about it. And I think that we are hoping that by creating this Listserv, we can cut down on all of that time. And we can also help provide suggestions that we found in our time of doing cases like this over and over. So one example would be, oftentimes prisoners themselves will bring claims for deliberate indifference. And what attorneys who represent them may not know is that there is also a claim that you can bring under state law that has a lower threshold. It's called a medical malpractice. And there are pros and cons, certainly, to bringing that claim in addition to a deliberate indifference claim. But it's something that this Listserv could tell attorneys about and help inform them about why they may want to add this as a claim on behalf of their client, who may not know about it, and the attorney himself or herself may not know about it.
So to give them additional tools for representing their client and hopefully getting some sort of recovery for their client or some sort of restoration.
That's exactly right.
Sarah, in the time that you've been doing prisoners' rights litigation, where have you seen things going? Where is the law going in prisoners' rights?
I think that courts across this country are really beginning to recognize the need for constitutional protection of prisoners, given the overpopulation of prisons across the United States and the increasing use of for-profit companies in providing essential services to prisoners. Those companies who are inherently incentivized to deny care.
Because that's how they make more money. Provide less, get paid the same amount, make more profit.
Exactly. These often medical care companies or private prisons get paid a set amount, and every dollar that they spend actually providing care or fulfilling what is a constitutional responsibility takes a dollar out of their profit margin. And I think that there has been a growing recognition of that problem and the perverse incentives that it creates in our prison system. And I think that the Supreme Court and the circuit courts, as well as district courts across the country, are really coming to a greater awareness of these problems and the resulting deficiencies in the constitutional protections that prisoners are entitled to.
Are you seeing that in the outcome of cases? I mean, can you, for example, identify particular decisions that you think reflect that kind of shift?
Absolutely. The most recent and perhaps most well-known example of that is the Supreme Court's decision in Kingsley v. Hendrickson, which was a case decided last term, in which the court was presented with the question of how to analyze claims of excessive force by pretrial detainees who had not yet been convicted of a crime. The detainee himself, who was arguing before the Supreme Court, had argued that his claim should be judged based on an objective standard, and that's what's used out on the street. The question is whether or not a reasonable officer in that situation would have used the same amount of force as was used in the case before the court. The prison officials argued in support of their position that jails are an incredibly dangerous place, and that to look at these claims of excessive force on an objective standard would cause these officers pause, and that pause would create an atmosphere of absolute chaos. And so what was needed was very great deference to correctional officers, including requiring their hearts to be guilty before they could be found to have violated constitutional rights. And what the court did in rejecting that standard and finding that the claims should be based on an objective standard about what a reasonable officer in that circumstance would do was to recognize that pretrial detainees haven't been convicted of any crime. They retain constitutional rights, and those rights require protection that should not give way to near total deference to correctional officers.
Do you think, and I realize this is a hypothetical, but do you think that if that case had been brought 10 or 15 years ago, it might have gone in the direction of the prison officials' argument?
I think if this case had been brought in the 90s, it almost certainly would have gone the other way. During a time of some hysteria about crime, I think it certainly would have gone the other way. And I think the justices have, in encountering these cases repeatedly, have come a long way in recognizing that what goes on in jails and prisons is not just mayhem on behalf of people who are incarcerated, but are problems that are caused by prison officials and the private companies as well.
Do you think that the public is changing its ideas about prisons and what should be or shouldn't be tolerated in them?
I think so. I think that the most popular idea now is the idea of overpopulation because of drug crimes. And I think that is very helpful from my perspective as a prisoner's rights advocate, because it helps me to educate the public about what's happening to people that a lot of folks think shouldn't even be in prison to begin with. And to see not only what happens to them in prison, but the effect that has on their ability to be a helpful and contributing member of society when they're released.
Sarah, for you as a prisoner's rights advocate, where would you like to see the law go? Is there, for example, some specific issue that you'd like to see resolved a certain way, or that you think is on the verge of being resolved either positively or negatively?
I think the next big step for prisoners' rights advocates is the issue of solitary confinement. For the past several years, solitary confinement has been used to lock up problematic prisoners, which includes, unfortunately, a lot of people with mental health issues, and also people who had security issues that we really didn't want to deal with. So some of the prisoners who are most at risk of being subjected to unfair solitary confinement are transgender prisoners or gay prisoners or other prisoners who the correctional administration can't easily figure out how to deal with in a way that doesn't subject them to, frankly, to death and substantial abuse. In a case decided last term about racial bias in selecting jurors, Justice Kennedy concurred and said, one of the things I find most troubling about this case is the man who brought the case has been held for a number of years in solitary confinement. And he wrote this beautiful concurrence about how being held in solitary confinement under the conditions that come along with that is, he suspects, in violation of the Eighth Amendment's guarantee to be free from cruel and unusual punishment. And I really encourage everyone to read it. It was a really beautiful concurrence.
And this was in a case that did not raise any issues about solitary confinement. Justice Kennedy just took the opportunity to put it out there and put it on everybody's radar screen.
Absolutely. It was not mentioned during oral argument except for Justice Kennedy asking about it in one question. And it was not an issue to be decided in the briefing. It certainly wasn't an issue in the case as it was presented to the Supreme Court. But as many people know, Justice Kennedy is often regarded as the swing vote for a lot of important social issues. And so when Justice Kennedy writes a concurrence like that, I think it's very encouraging to people and prisoners' rights advocates across the country that this is an issue that the Supreme Court is paying attention to, and one that I expect will come to the court soon.
All right, well, Sarah, thank you very much, and good luck with the Prisoners' Rights Listserv.
Thank you very much, Gretchen.
If somebody wants to join the Listserv, how would they do that?
They would go to our website at www.loevy.com/prisoners' rights listserv.
And that's LOEVY.com.
Yes.
All right, thanks very much.
Thank you.
Sarah Grady's an attorney doing prisoners' rights litigation here at Loevy & Loevy.